where it said you guys were going to close my case? Or
I did not.
no? Okay.
I think
Is that part of the file, or that's not part of the file?
That's not part of the course file. Here, that's the one.
No.
I'm including the ones I have copies for. All the stuff you may not even need. Do you want copies of it? No. Okay. It's just stuff you have. And then this is the one I did. You have a copy of that? That long one?
No.
All right.
See?
I was just looking at, I didn't get a chance to look at the big one, but I think we can handle these report issues and see maybe I can grab it then.
All right, then. All right, so I can say, both parties present?
Yes. How much is it?
You have to, bring them up to the bench, please.
Can I use this as a little table?
Sure.
Okay. You can come on, 'cause, well, I guess Judge can see you there. Can you see him?
Yeah.
Oh, Judge, I think I missed a motion. Did you get his, counter motion for show cause and request for de novo hearing?
Yeah, I got that.
Okay. That's what I would like to address today.
Okay, we're going to address that along with, proceed, in one of purpose. It's a purpose affidavit of sorts, so we'll go ahead and take care of all this then. Thank you. All right, this time, court's gonna go ahead and call on the record, Bell County calls number 286,540. This is in the 426 Judicial District Court of Bell County, Texas. It's in the interest of, and again, let me get the correct pronunciation. How do you pronounce your last name, sir?
Kuyate.
Kuyate. All right, in the interest of a Kuyate minor child, non-custodial party being, and how do you pronounce your first name, sir?
First name is Cherno.
Cherno. Kuyate, and custodial party is, ma'am, how do you pronounce your Virchel? Virchel Griffin.
Yes.
And this matters before the court on a motion for enforcement of child support and medical support. The court's taking judicial notice of the court's information and file, and note for the record that this was filed by the state of Texas back on the 7th day of November, that there was service citation issued on the non-custodial party, and he was actually served with this information. Let me get the correct date.
That date, I'm sorry, Patricia.
Your Honor, if I may, on the show cause,
Yes, ma'am.
I believe the return, if the court was to look at it, it shows that he was served on December 11th of 2025. So it's an incorrect year. However, I would like to call Mr. Kuyate to confirm what day he received that.
All right, and the court will note, let's see, that he did file a response. Okay. Let's get to that. Yeah, and in his response, he did say the same thing, that he was served on December 11, 2025. Obviously, that's not correct, but we'll get the clarification on that. The court will also note that he has also filed several items. Again, one is the equivalent of what we call a request to proceed without paying costs under a pauper's affidavit. And he's also filed a request for de novo and an objection to the court, the associate judge hearing this matter. The court will first off address the objection to the court, and what I'll tell you what, I'm going to let the state verify the actual date of service, and then I'll deal with that also. So at this time, I'm going to ask that the court will note for the record both parties are properly given notice and served in accordance with the Texas Rules of Civil Procedure. The custodial party is present, the non-custodial party is present. So at this time, I'm going to ask them both to raise their right hands and let me get them under oath, and then we'll proceed on all motions as necessary for this matter today. So at this time, do you both solemnly swear or affirm that any testimony you give this court today is the truth, the whole truth, and nothing but the truth will help you?
Yeah.
All right, you both officially under oath, and I'm going to let the state call you as a witness, and we're going to do some clarification stuff first, because this is a motion for enforcement, and at the end of the day, the state in that enforcement was requested incarceration, so we're not going to get into that until we get to the issue of whether or not the NCP should get be entitled to court-appointed counsel, or if he wishes to hire his own private counsel for this. But since he filed the pauper's affidavit, I'm going to assume that that alone would be sufficient, and more than likely to give him court-appointed counsel in this matter. So at this time, I'll allow the state to go ahead and proceed and verify the information concerning service and everything else, please. Thank you.
Yes, Your Honor, the state would call Mr. Cherno, it's a Kuyatek, only for the purposes of stated. Mr. Kuyatek, you received a show cause order, and you filed an answer that you received it on December 11th of 2025. Do you agree that you received it on December 11th of 2024?
Yes.
And you also received a notice of hearing because you're here today. Did you also receive a notice of hearing for today's date?
Yes.
Now, you also filed what the judge said was a pauper's affidavit. So do you want me to address the court-appointed attorney, or you want to do that?
Well, first thing
I'm sorry. So I never received this. I actually received this.
The show cause?
Yeah, I never received this.
The notice of hearing? May I approach, Your Honor? May I approach him? Okay.
Yeah,
All right,
that's
so you received the order to appear and show cause. This is filed by the state on November 7th of 2024, and it has the hearing date of March 5th, 2025 at 9 a.m. So you received notice for today.
Okay, but you're talking about the form.
Yes, I understand.
Okay,
But you
so-
received this one, the order to show
Yes.
cause. Your
But
Honor,
to answer your question, I did not receive that form. I received this one, even if
Okay.
information is included.
all right.
Never received that form.
So you did not receive the notice of court
No.
proceedings. All right, but you did receive the order to appear and
Yes.
show cause. We ask the court to take judicial notice that order to appear and show cause was filed by the state on November 7th of 2024.
All right, the court will take judicial notice of that. The court will verify, based on the testimony of the NCP, that he did receive this information in December of 2024 and not 2025. And sir, based on the date that you were served with this, you had there was so many days you had to object to this being heard by an associate judge, and your objection came long after that deadline has passed. So actually, this court has the absolute right to take this matter up without transferring it to the district court at this time. That's the only ruling I want to make as of right now, that this is properly before the district court, before the 4D court at this point. Next, I'll ask the state to continue with their opening as far as what the state wishes to do here. Again, sir, I read over your affidavit of inability to pay costs, and technically what it is. And right now, there's no court cost involved or no cost to yourself for filing anything in this court or proceeding in this court. However, sir, based on what has been served on you, you have the absolute right to have a lawyer represent you in this case. If you cannot afford one, and your affidavit is pretty much telling the court you cannot, and if your getting 100% VA disability, I would take that as prima facie and not include that as your income, and say that you are eligible for court-appointed counsel if you wish. So again, sir, this matter contains contains a request that you be held in contempt and possibly sentenced to jail and possibly have to start serving the jail sentence. Do you wish at this time, sir, to proceed and on a request to have court-appointed counsel, or do you want to go ahead and just proceed on everything? How do you want to do this, sir?
I want to take the counsel, Your Honor.
You want to see about getting court-appointed
No,
counsel?
no counsel.
All right, so you realize at the end of the day, sir, you can end up with a jail sentence and end up having to serve that jail sentence. Is that correct, sir?
Yes.
So you're knowingly at this time waiving your right to court-appointed counsel. Is that correct, sir?
Well, we're here just for the show cause. So this entire order is void. So I don't understand why this is all going on at the end of the day.
Okay, the show cause order is not void, sir. The show cause order is orders you
My
to
child
appear.
support order. I'm looking at, from the feds, financial support for children, from benefits paid by Veterans Affairs. Literally states to state agencies administering child support enforcement plans under Title 4D of the Social Security Act. And it lists everything that the state is able to do and they are not able to do. I'm not retired. I'm 100% disabled. I never waived any retirement pay. So for you guys to use my VA pay to charge me almost $700 a month when I have a VA apportionment ruling, and they use all the information you guys somehow use, and they stated that I only owe
Your Honor, the
$140
state's gonna object.
a month.
That's finished.
Okay.
Go ahead and finish, sir. All right. You through, sir?
Yeah.
All right, here we go, sir. The court has the absolute right to look at what you receive the payment from the VA for setting up child support. We do not, this court has no authority to touch that money in any way, shape, or form direct coming from VA. We cannot do a wage reporting order and get that money directly paid. That is 100% correct. However, those are funds that are available to you through the federal government. We can look at them for the purposes of paying ordering child support, and the court has done so in hundreds of cases, and will do so going forward. That is your legal obligation based on what your earnings are, and they are tax-free earnings, sir. So to tell you're right. You understand you said an apportionment for a portion of that. It's been done, but that wasn't done by the state. That was more likely done by the receiving party and the custodial party. So anything that's not been paid in child support by you through the state dispersing you, we're not asking to hold the VA in contempt. The state's not asking that. They're asking that you be held in contempt for your failure to pay child support through the state disbursement unit based on the earnings you get from the VA. And we have and the court on the fine, sir, we definitely have jurisdiction over you. And we're friends of us. So what's your response to that, sir?
I have a letter from the Office Attorney General dated August 5th where they told me, and I also have the emails, they were going to close my child support case because I have my VA apportionment. And this is August. In November, December, they served me.
Okay, well, here's your sir. Your case with them is something totally separate. This case has been filed in this court. And right now it's before me. And obviously that hasn't been closed.
I can't afford child support. What the VA sends to my fiduciary directly, that's all I can pay. So my house has been on foreclosure.
You're going off focus here, sir. Again, right now I'm looking at having a hearing on this matter, dealing with whether or not the court should find that you fail to pay child support in accordance with the court order. It's kind of straightforward, sir. And you've already told the court you do not want a lawyer appointed to represent you on this. Is that correct?
Yes.
All right.
Judge, may I?
Yes, you may.
In fairness, I'm not sure if Mr. Kuyate was interested in trying to hire his own attorney.
Well, he's telling me he has an inability to pay costs. So, sir, are you interested in trying to retain your own counsel?
Yeah, I'll see if I can get one.
All right then, sir. Bill, I'm going to have the state do a reset order. I'm going to give you every opportunity to get your ducks in a row on this, but I want to let you know, sir, this kind of thing's come up before, and the court's always been able and has always gone for it. And at the end of the day, you need to run this by a lawyer and have your lawyer and see about retaining counsel and get your lawyer come here and advocate for you in accordance with the Texas Family Code and the Texas Rules of Civil Procedure. This is not a federal matter, sir. This is a straight out of Texas matter. And at the end of the day, after the court has made its ruling, you will have the absolute right to de novo back to the district court. But for right now, there's nothing to de novo to the district court.
Yeah, 10 days after the ruling, yes?
Yes, sir.
Okay.
So you have up to 10 days after there's been a ruling, but there hasn't been a ruling made in your case, sir. Other than the rulings that the court does have jurisdiction to go up. If you want to go ahead and try to de novo, it's a little early, but the court has not, you know, it's up to you one way or the other, how you want to handle it. But I'm going to go ahead and give you the opportunity to seek legal counsel, sir. I'm looking at going ahead and instead of resetting this for the first Wednesday in April, I'm going to go ahead and give you a little extra time and reset this matter for our recess and commitment docket, which is going to be on should be the 16th of April.
I would have to ask.
It's the 16th. It's exactly 2 weeks after the second. So yeah. So at this time, sir, that's going to give you approximately 6 weeks to seek legal counsel. You think is that enough time for you, sir?
No.
How much time do you request the court to do?
90 days, Your Honor.
All right, sir. I'm only going to give you the 6 weeks. Okay. 90 days is too far out. If you're not paying your child support, I'm not going to do this. I'm not going to let it go. I'm not going to let it go for 3 months, sir. I'm not going to let it go. So you need to go out and find your lawyer, get some legal advice, retain your counsel. If your counsel needs more time and makes a legal request for continuance based on them needing more time, then the court will pick that up. But for right now, sir, I'm not going to give it I'm not going to set this out 90 days until I am assured that you're really seeking legal counsel and that you're looking at retaining counsel. Because again, we come back in 90 days, you don't have a lawyer, we're still in the same spot we're in right now. So I'll reset this matter to that date, sir, to give you 6 weeks to do it.
I have a question for you. So, when I come back, it'll be on a Wednesday, correct?
Yes, sir.
And you guys have 72 hours to keep me in jail before you offer bond, correct?
I'm sorry, sir?
You have 72 hours to keep me in jail before you offer a bond?
No, sir, this is contempt. Contempt is not a criminal case. Contempt is I can keep you.
6 months.
Yes,
Okay.
sir, for 180 days. Yes, sir.
Okay.
This is not a criminal matter. This is what the law calls a quasi-criminal matter because you can go to jail, but this is civil contempt, 180 days, day for day, sir. Okay. Any other questions, sir?
No.
All right, sir.
Well,
Yes, sir.
I'm sorry, Judge. I would like to address another issue.
Sure thing.
For clarifications before I move on to the other issue, the court denied his counter motion for show cause and request for de novo hearing.
Yes.
So no need to make arguments because it wasn't heard. It's just completely denied.
Correct.
Right. Judge, there's one more issue. I didn't get to really talk to Mr. Kuyatek because I wanted to bring him before the judge in front of you.
Yes, sir.
But one of the things that's going to be an issue in this case is that the child is receiving an apportionment already.
I know. I saw that.
And mom is in agreement with that. So I would like to ask if he will agree to do a trial amendment to address the modification so that we can go ahead and start giving him the credit for the apportionment that's already being given. Because if not, we're going to run into an issue, right? Of having to go back and do adjustments. So I don't know if he wants to agree to that. And if he does, then we're going to ask that he provide his income information, which is the VA disability.
I think you need to serve it. We may have to spread this out long enough to cover all those dates, but let's get a proper service, a citation, or a service by direct mail to them and get it done. So the state wants to go ahead and technically give you credit for the apportionment that the custodial party is receiving. And they want to do that by agreement, sir. But based on your prior pleadings, I'm a little hesitant to do that. But I will give you the opportunity to say, do you want to do that by agreement, sir? Or they can look at modifying your case and giving you proper credit, or do you want to be served with that paperwork?
Yeah, I'm not going to agree because everything that I've tried to work with the OAG before has never been in my benefit.
Okay,
So,
all right, then, so I'm gonna have the state go ahead and, we'll just have to, I'll have the state go ahead and dot their i's and cross their t's on that, all right?
all right.
All right, sir, yes, ma'am.
Do I have to be here? Can I do Zoom? When the next?
Okay, for the next hearing, ma'am, I will authorize you to do Zoom, okay?
Okay.
The one, I'll assume it, but if he shows up with a lawyer, then, and he gets the lawyer at the last minute, that can be a continuance, so I don't want you to show up and have to deal with that. If he doesn't show up with a counsel, and he has the right to still request court-appointed counsel, I will deal with that also. So for you to sit around all day on that, but for a final hearing, when we know all the ducks are in a row, we're gonna go ahead and see whether or not the court finds him in contempt and sentences him to jail. We want you at that hearing, and that may be the next hearing, but, the next hearing, the one for April, ma'am, I'll authorize you to be here by it, all right?
Yes, sir.
All right, thank you.
Thank you.
All right.
Yes, ma'am. Anything else?
No, Your Honor.
All right, ma'am, do you have any other questions?
No.
Okay, and the state is correct that you're willing to go ahead and give him proper credit for the apportionment that you're receiving, correct, ma'am?
Yes.
Okay, and you're the one that initiated that, correct?
Yes.
Okay, that's what I thought, thank you, ma'am. We can't do it. Yes, sir, do you have anything else, sir, or any other questions?
Not at this moment.
All right, then, sir, I'm going to go ahead and reset this matter, like I said, 6 weeks out to the 16th of April. Hereby ordering you on the record, sir, to appear on this date, could mean the court would issue a warrant for your arrest. You understand that, sir? Sergeant,
Yeah.
all right, thank you very much. All right, thank you very much. I'll let the state prepare the reset order and the information, and we'll get that signed off on. We're off the record. Thank you.
Yeah, give me 10 minutes, I'm just gonna print it and y'all can sign off on it. And I know you can do it.